You were coming home, a man was in your house, a woman was with him, they tortured your house, torched it, and assaulted you. Violent crime. But in that case, as you would expect, that person is going to be prosecuted as a felon. But if you could just change the definition, we could just call it a violation or something. Or we're going to try to make you comply with something and call it contempt. No jury. As you know, the Supreme Court is hearing a case about fathers put in prison without counsel. You may not even have a right to counsel. Call it something else. We can take all your constitutional rights away. Those Bill of Rights, out the window. So how did he get away with this? How did he violate this rule of natural law in these cases? They simply called it something else. You've got to find out a good trick. And you could turn this new rule, this natural right, into a gold mine. Greater than the gold rush of 1849. All they did is they said, we the state are looking out for your child, and your child. We know more about your child and how to raise them than you do. We weren't there when they were conceived. We weren't there when they were born. Of course, we protect them and have military and that sort of stuff. But the parent-child relationship is by definition private. You don't interfere with this stuff unless you have to. Now, if there's violence and it's erupted out onto the street, we expect the state to get involved. But in answer to that question that I got in that radio program, the answer to it is the state should never get involved if it's not necessary. They say, and I want to backtrack to something, beginning our Constitution, our beginning as a nation. We had a Constitution that was developed by our founding fathers, and they came back together in a convention. And right now at the forefront, the Supreme Court case, Troxel versus the Granville, the year 2000 was the last time the Supreme Court visited the issue of custody and what they called visitation. And that was a grandparents' rights case. We're still waiting for this kind of a case, which we are principally talking about here, to make it to the Supreme Court. That's what I am doing. I have filed a number of test cases. I currently have a lead and what's called a lead case and a member case in federal court here in this district, the Northern District of New York, and it's been consolidated. I sued the Unified Court System, a number of judges in this state, lawyers. Tim would be happy about that, and various other parties because of their role that they play in the family court process. And the judge denied the motions of the judges to dismiss that case in November, consolidated the cases. We've had all the arguments on it. It's been pending for 2 years altogether, and on or after April 29th of this year, 2011, I hope to have a decision. And I will take that to the courts. I've already filed one writ with the U.S. Supreme Court, but the record wasn't sufficient. So there's going to be a lot of obstacles. This is an extremely uphill battle. The investment that I put in here in time alone well exceeds. If the casino case is any example, there's a lawyer in Madison County made $1 million already fighting the Turning Stone Casino on behalf of 9 of Madison counties. If that's any measure, then I'm well into the millions on what I've done here. And comparatively, I've done well in my career. But that right they are now taking from us. Troxel versus Granville is an example of that. If you look at parentingrights.org, some of the material that you see and I'm hearing, even among people talking to me at our social function last night, one gentleman from New York, who I'm happy to see is here, I met him at the Plaza Hotel in New York City. And as he was speaking, the words he was using came right out of a video from parentingrights.org, and he was discussing government philosophy and how it interferes with children. So we have a lot of very educated people here. But they're trying to make the claim right now that the parenting right does not exist in the Constitution. Justice Scalia said that in his dissenting opinion in Troxel versus Granville. I don't see it in the Constitution, so it must not exist. Well, the abortion right doesn't exist either. So if you want to look it over, check it out, you will not see the right to abortion in the United States Constitution. How did it come about? Well, as they say, constitutional scholars will tell you, it's a right that springs from those other rights. And there's this penumbra, they call it, which is actually a figure from astronomical terms where two spheres, they come together. And there's that area in between, that vague, shady area. And then they use several rights. They said, well, there's privacy in the Fourth Amendment, and we've got these other amendments. And then they put it all together. They even used the Ninth Amendment. I think that's the only case that really relied on the Ninth Amendment for a right. And they came up with, voila, the abortion right. At the same time, the parenting interest, which the Supreme Court has correctly pointed out by another speaker, it is the oldest liberty interest protected by the Constitution. I believe that's the Philadelphia speaker, correctly pointed out. It is the oldest liberty interest. The Supreme Court has declared it as such. But here's the big thing about parenting that's different than abortion, aside from the destructive nature of abortion. But the parenting right is, imagine yourself in 1780s and at a convention of delegates, much like we are delegates here today,